Settle closure of this matter. And I enter the board for resolution.
You are not on the record unless you're up at the lectern. Mr. Taylor, please come forward.
Let the record show that I'm entering the board for rest of my rights and remedy. Good morning, Your Honor. Before we begin, I'd like to...
I'm sorry, sir. I'm sorry. You're represented by an attorney. I'm going to speak with Mr. Taylor in reference to your case as he represents you.
Your Honor, I am a man of sound mind at the age of majority.
Sir, I'm going to talk to Mr. Taylor about your case. Do you need to talk to Mr. Taylor before we proceed?
He's not my attorney, and I don't have an attorney.
Sir, I'm going to talk to Mr. Taylor about your case. Mr. Taylor, you represent Mr. Dang?
Yes, Your Honor, I was appointed to represent Mr. Dang.
Your Honor, who
I
is Mr.
understand,
Dang?
excuse me, please do not interrupt these proceedings or I will ask you to leave.
Your Honor, I need to put
Sir.
things on the record to clarify my...
Sir, please do not interrupt these proceedings. Mr. Taylor, I understand that there is currently outstanding an order by this court that requires that a competency evaluation occur, and that hasn't occurred. Is that true?
That is true, yes.
Do you know anything about the scheduling of that?
I did speak with or emailed the head of the Community Forensic Evaluation Services at Western State Hospital, Gina Julia, and she informed me that the out-of-custody evaluations are taking approximately 7 to 8 months from the date that that order was received by Western State. So that would put the timetable at June or July in this case.
So it seems to me that because of that, there's not anything that we can really address on the record today while that's pending. And my suggestion to the parties is to continue this matter until such time that we anticipate the report will be completed.
That's fine.
Ms. Stone?
No objection, no, I think that's accurate.
I'm sorry?
No objection, I believe that that's accurate, Your Honor, that we can't proceed without Mr. Dang's competency returning.
And so I just want the parties to be aware that I don't anticipate in the other cases at today's hearing that I will continue them. I haven't heard from them yet, so I don't know. But my ruling in this case, continuing this matter out to such time that we expect the report to be received, may mean that this case might be, the trial might be different than the other cases. And I just want the parties to understand that.
Understood, Your Honor.
And so do the parties propose a date in June or July?
I think a date in late June would make the most sense, just to track things, so I would propose sometime in the last week of June, what the court's availability looks like. I can propose a specific date if the court wants me to.
I think we should. My preference would be a Wednesday or Thursday morning at 8:30.
Sorry.
For a trial confirmation, Your Honor,
Competency review.
I'm fine with anything in this last week, so I would refer to Mr. Taylor if you have a preference between Wednesday and Thursday.
I don't. Let's go with June 26th, Wednesday. Just to take a date.
So June 26th, we can set that on for trial confirmation as well. I'm not sure if the parties are going to be prepared to address trial confirmation at that time.
I can tell the court I will not be prepared to address trial confirmation the same day that competency is addressed.
So we'll simply address competency that day.
Thank you.
Your Honor, before you conclude the business for the day, I need to ask a question. Does this have anything to do with I? Does this cause number 18-1-00438 have anything to do with I, the life man, the beneficiary, the creditor of Sesquivy Trust Community thing? Does it have anything to do with I?
If you have any questions, please ask your attorney, Mr. Taylor, who's standing beside you.
Your Honor, you're saying he's my attorney. Do you have a contract?
Sir.
Is there a contract for that you appoint him as my attorney? To have I consent willingly, knowingly, intentionally, intelligently, unequivocally to his being my counsel?
So we're just about done with this hearing.
We're not
Sir,
done.
Please don't interrupt me when I'm speaking.
I won't interrupt you, but you cannot interrupt me when I'm speaking as well.
Please don't interrupt me when I'm speaking.
Okay, well then finish speaking and I'll speak.
We're almost done with this hearing. Any questions that you have cannot be asked to me, but can be asked of your attorney, Mr. Taylor. So when we're done, and we're almost done, you can ask any questions you have of your attorney, Mr. Taylor.
We're not done. I'm not asking any question. I'm putting things on the record. First of all, Your Honor, I'm being very respectful as I can. I appreciate if you don't interrupt me when I'm speaking.
Sir, I
appreciate
need
you
to
don't want
interrupt you. Sir, I need to interrupt you because you're disrupting these proceedings. And if you continue to do that, I will ask you to leave.
Does this proceeding has anything to do with I? Because if it has nothing to do with I, then I'd be more than happy to leave.
Please ask any questions of your attorney.
I don't have any
Now-
question. I need to put things on the record. That's
Sir?
the thing. He's not competent to answer any questions. He's not competent to handle any of this affair.
Sir, I'm done hearing from you at this time, so if you have any questions, please ask them of Mr. Taylor.
Does this have
And we're
anything to
going
do with
Sir,
I?
please. We're done with that question. As I indicated, you can ask Mr. Taylor after the hearing is over.
Why are you railroading me and why are you silencing me in court? I have questions that I need to answer. I need to know this case has anything to do with I. If it doesn't, then I need clarification. I need to know the nature and the cause of the accusation. I don't know why we're going to trial to all these pre-trial for almost a year where you're wasting all the public resources, wasting your time, wasting everybody's time here.
I understand that you have a lot of questions of your attorney. Please ask Mr. Taylor.
Your Honor, if you keep saying he's my attorney, can you show me the contract that he's my attorney?
All of these questions need to be addressed by your attorney.
He's
And
not
I
my attorney.
understand.
I'm a man of sound mind and at the age of majority. I can handle my own affair. I don't need anybody. This court does not have power of attorney to make any decision for me whatsoever. Any power of attorney between the state of Washington and Dan Comatrongia has been revoked, rescinded, retracted, and terminated on August 9, 2018. I have proof of that. And not to mention, this court has no jurisdiction or authority or whatsoever to make any decision for me as the life man. Now let me put things on the record before you finish, because I have questions. I need to know that this is not wasting everybody's time here.
Sir, I'm not going to answer your questions today. I know that's what you want.
Okay, then when are you going to answer the questions?
Excuse me, but that's not what's going to happen. So, I'm going to ask you to just stop interrupting these proceedings. If you do it again, I will ask the clerk to call security and have you escorted out of this courtroom.
Does this proceeding have anything to do with I? If it doesn't, then I will not interrupt this proceeding. I would
For the last time.
disrupt this.
For the last time, your questions are more appropriately addressed to your attorney, Mr. Taylor, who's standing beside you.
For the last time, I don't have an attorney.
You have the opportunity to ask him those questions after this hearing is over.
I don't have an
And if you
attorney.
interrupt one more time, I will ask the clerk to ask security to escort you out of the courtroom.
Are you done?
So, we're going to be signing an order. Ms. Stone, do you have the order prepared?
I don't, Your Honor, I'm gonna ask, I just emailed staff because I didn't realize the crash cart wasn't in here and asked them to bring in copies of the orders.
So as we proceed throughout the morning, I anticipate many orders being signed.
Yes,
I
ma'am.
expected the parties to be prepared for that.
Yes, Your Honor, we'll grab them, as I've indicated, I've asked them to bring in a stack of them.
Well, we can't finish this proceeding until we have that.
Well, if the court will excuse me, then I'll run out.
So what I'll do is I'll ask the clerk to give you a blank order.
I already did that, Your Honor, she doesn't have any.
Oh, great, Your Honor. Now we have time.
Excuse me. We have no orders in this courtroom.
Apparently not, Your Honor.
Ms. Pilata went to go try and get some.
I'm baffled that parties would appear without those orders. So I'll just say this. We have many other hearings scheduled and many other attorneys in the courtroom. I hope that all of those attorneys are prepared with proposed orders. I anticipate entering orders on all cases this morning.
Let the record show that I'm a third-party intervener appearing specially as a paramount security interest holder and authorized representative agent for person Dane Comatrongia. Let the record show that I'm appearing specially as a beneficiary and creditor to the Seskivy Trust Trongia Dane. Let the record show that I'm a man of sound mind and the age of majority appearing especially under protest, threat, arrest, and coercion. Does anyone in this courtroom here today now have an original charging instrument or an accusatory instrument or a claim for my inspection?
So we're agreeing to continue this matter as a competency review to June 26th, is that
Yes.
correct? June 26th at 8:30. I will sign that order when it's presented. Do we need to address anything else on the record today?
Let the record show that no one presented with
Please
an
don't
original charging
interrupt me.
instrument or an accusatory instrument or a
Sir.
claim against a person named Thomas
Sir.
Trunier, that constitutes prima facie
Sir.
evidence that nobody in this courtroom has stated a claim upon which relief can be granted. And this case
Sir.
shall be dismissed with prejudice.
Please stop speaking.
Your Honor, I didn't
Please
interrupt
don't
you.
interrupt me. I'm speaking now.
Okay.
So we
finish.
are completed with this hearing. I will sign that order when it's presented. I am not certain whether the defendant will sign the order or not. So the record will reflect that the defendant was present when the court ordered that the next hearing will occur on June 26th at 8:30. I expect counsel and the defendant to be present for that hearing, and we are completed with this hearing. We are done. The next matter that I will call is State versus Hume, cause number 18-1-442-34.
I'm here to assist the court with that matter, Your Honor. May I enter the bar with full reservation of my rights to remedy?
You are not on the record. You need to be up at the lectern here in order to be on the record. Ms. Collada, represent Mr. Hume.
Let the record show I enter the bar with full reservation of my rights to remedy.
And the defendant is present. Good morning. Please don't interrupt these proceedings.
I am not the defendant, Your Honor. I am a third party intervener making a special appearance of a paramount security interest holder and authorized representation for the person, Quinn Michael. Now, does anyone in the courtroom here today have an original charging instrument or an accusatory instrument or a claim for my inspection?
Please don't interrupt these proceedings. Ms. Stone, you represent the state, correct?
I do, Your Honor.
And Ms. Collada, you represent the defendant.
Yes, I have been appointed by the court to represent.
Thank you. So we are here for two matters. The state has filed a motion in limine, and we are here on trial confirmation. First, I would actually like to address trial confirmation.
Okay.
Are the parties prepared to proceed to trial?
The state is prepared, Your Honor. Yes, Your Honor.
And have the parties prepared a trial confirmation order?
We're in the process of preparing that order, Your Honor.
Your Honor, once again, does anyone here today have an original charging instrument or an accusatory instrument or a claim for my inspection?
Sir, I will not be answering your questions. Your questions are more appropriately addressed to your attorney.
I don't
Ms.
have an
Collada,
attorney.
please don't interrupt me when I'm speaking. Your attorney is Ms. Collada, who's standing beside you. She is your attorney in this case. And excuse me, please don't interrupt me. And any questions that you have, you can address to Ms. Collada after this hearing is over. Please don't interrupt these proceedings. I may ask to have you escorted out of the courtroom if you continue to interrupt these proceedings. Ms. Collada?
Yes, Your Honor. I'm filling out the trial confirmation order now, and I would seek input from the prosecution on that because I know we'd actually set it for 3 weeks. So I believe that.
What do you anticipate to be a reasonable time for trial in this matter?
I feel like I'm not in the best position to say that because I don't know if these other co-defendants are confirming as well.
I would assume that they all are.
Then I would suggest that at least 12 to 15 days would be my best.
I think that's accurate, just based on the amount of, not so much the volume of information as the combination of the volume of information as well as the volume of people involved. So I think to say 2 to 3 weeks is reasonable.
I actually don't anticipate it taking that long.
Okay.
And we will not be in trial for that long. I will carefully address issues of evidence in this case and witnesses and make sure that the evidence addresses the issues in this case and not issues that are unrelated to this case.
Yes, Your Honor, then I think we could go much quicker than that. The state is trying to err on the side of caution in terms of time. They don't want to be underestimated.
What is your reasonable estimation of time?
2 weeks. Your Honor, I think 2 weeks is.
So when you say 2 weeks, that means to me 8 court days.
That's what the state means, Your Honor, not 10 days, but I'm talking trial weeks, 2 trial weeks.
And that, in my mind, includes jury selection, and it includes openings, testimony, addressing any issues that come up during trial, as well as closing arguments.
I believe so, Your Honor. As I was going through the state's witness list last night, I'm working very hard to take out as many people as possible to streamline and keep the trial as short and efficient as possible, understanding that there are 5 other co-defendants.
Ms. Collado?
Your Honor, I am modifying the confirmation order to reflect the 8-day count, given what the court has said about evidentiary rulings and also what the state has said. I'm willing to defer to both of those conversations.
Do you believe that's reasonable?
I think the only thing that would color my judgment on that is the notion that I think motions in limine might take a whole day because of the number of attorneys and co-defendants.
I actually don't disagree with you, and that's something I'd like to address in this hearing. I think we should set aside a day prior to trial for motions in limine.
No objection to that.
No objection.
And what day do you propose that we take care of that?
I'm fine with any time during the week of the 8th, of April 8th. I don't know what the court's preference is in terms of if the court prefer to do it earlier in the week or do it later in the week, or if counsel has any particular conflicts. As far as I know, my week is entirely open that week.
And Your Honor, I have multiple trials set that week. I know that's not a guarantee I'll be in trial, but I would request that Friday, April 12th, if the court's available. And recognize that might be difficult for the court as well.
I can't imagine I'm available, but I'm looking at Mr. Bales. I imagine I have a calendar all morning long of matters that have been set for quite some time, and probably a hearing scheduled all afternoon as well, and he's nodding.
You want to speak now?
You can ask your attorney questions after this hearing is
Once
over.
again, I don't have an attorney, but there's something an attorney.
You can ask your questions of Ms. Collada when this hearing is over. So, in terms of motions, we'll also need to look at a briefing schedule for those motions.
Your Honor, if I'm not in trial the week of the 8th, I feel like I could be available Tuesdays and 9th.
So, what do the parties anticipate in terms of the time needed for additional motions in limine? Like a half day?
I think with all the co-defendants, a half day would be sufficient. I don't think I personally would need a half day just for my motions.
Okay,
Does that make sense?
that does make sense.
I think that's accurate, Your Honor. I would agree.
Okay, so perhaps we should set aside Tuesday, Tuesday afternoon for motions in limine. All briefs by both sides in any motions would have to be filed by the day before. So I want the parties to think about how to schedule any motions in limine where the motion would have to be scheduled, let's say, by, I'm thinking maybe by April 3rd, and then any response by April 8th, and then the hearing on the 9th at 1:30. So in looking at the trial confirmation order, Ms. Stone, you've checked PowerPoint.
I checked PowerPoint.
Oh, you checked PowerPoint. So what does that mean to you?
I plan to use PowerPoint for the closing at this point.
Okay. So that's not evidence in the case. That's going to be a demonstrative exhibit. And does that include exhibits or recordings within it?
Not at this, I'm not aware of that at this time, but what I would plan to do is to provide a copy of my PowerPoint to the prosecution and Your Honor prior to actually giving it in front of the jury so that any objections can be raised.
Very good.
I don't generally use PowerPoint in opening, only in closing, Your Honor, so I would not anticipate, unless Ms. Zoe is on this case with me, she's not currently present, unless she was going to do something to the contrary, but if it is, we would certainly speak with defense counsel about it prior.
So you have the same plan, each counsel in this case, with
yes.
regard to PowerPoint, if you use it.
Yes, Your Honor.
Excellent. With regard to video, that was checked as well. I'm not sure who checked that box.
There's video surveillance associated with this case, Your Honor. Ms. Collada checked it, just knowing the discovery and the evidence in the case.
Okay, so I want to know what the parties anticipate in terms of the evidence in this case. I understand that the case involves video. I obviously haven't seen it. Do the parties anticipate any evidentiary issues coming up with regard to video?
Depending on what the state seeks to admit, I think that potentially an objection based on relevance.
Ms. Stone, have you presented to Ms. Collada any video excerpts that you plan on using at trial?
Not the excerpts, we haven't cut it out, Your Honor. We've given them the entirety of the video surveillance, and certainly the state wouldn't be playing all of that because we would be here for forever.
By what
We
date?
decided.
By what date do you propose providing exactly what you propose to use at trial to Ms. Collada?
We can do that. Well, I'll try and get that done to her by the 3rd. Obviously, today is the 28th. So
It actually needs to be prior to the 3rd because Ms. Collada would need to file a motion on the 3rd if she disagrees.
I'll do it then, I guess, by the 2nd. That would be because we only have obviously part of today. I'm obviously not located in this building any longer. So the 28th, 29th, I would have a tour by Tuesday. And it would be the same for all council. The date would be the same.
You know, I haven't heard from Ms. Collada, but if it were me, a day would probably not be enough to review, videotape, and draft a motion.
Well, in fairness, Your Honor, Ms. Collada has all of the video, so she's aware of what's on the video.
Right, but that's not what I'm talking about. What I'm talking about is prepared for motions in limine. She can't decide whether she needs to move this court to address evidence, specifically the video, that might be used at trial until she knows what the state will be using at trial.
Well, I can give her a draft copy on the 1st of April, which is Monday.
And Your Honor, I think that's sufficient, assuming it's not voluminous in and of itself. I presume, and maybe this is incorrect, that excerpts means 15 or 20 minutes of surveillance tops. And if that's the case, then the first would be sufficient.
Tops. Your Honor, nobody wants to sit here that long.
Very well. So I appreciate that. That should be, it looks like Ms. Stone is writing that down perhaps in a draft order. Excellent. And then another box is checked that says cell phone, other. Again, I'm not familiar with the evidence. Ms. Collada, do you know what that means?
Your Honor, it's my understanding there were two cell right data dumps of two of the cell phones of the co-defendants in this case, and that would be used by the prosecution to potentially link the other co-defendants to those two individuals' activities.
Are you familiar enough with the evidence to agree to the admission of that evidence or to address the objections you might have?
I believe I'm familiar enough to address the objections that I do have.
And so do you believe that through the motions in limine that we're discussing now, if necessary, if the parties don't come to an agreement, the court can address any disagreements as to that cell phone evidence?
I believe so.
And the reason I'm asking all of these questions is because the boxes are checked that say contested and foundational.
Yes.
And it would be my strong preference to address any issues that can be addressed at that hearing scheduled for April 9th at 1:30, and so they would have to be briefed before then. Do you think that's reasonable?
I do think that's reasonable.
The parties have not indicated any conflicts for the time of trial, is that correct?
You know, I have witnesses that have conflicts, but I believe I can work around those conflicts in terms of scheduling them at different points during the course of those 2 weeks. And I have one witness who has indicated they're not available at all, but I don't think he's material, and so I'm not concerned about that individual. So from the state's perspective, I don't believe I have any conflicts that I can't work around.
Thank you. And are there any other issues that the court needs to address prior to trial or set any other hearings in this case?
Well, I think there may be a need, and this could likely be addressed on the same day as motions in limb, that Mr. Quinn may want to proceed pro se at some juncture. And I want just to advise the court of that. At this time, it's my understanding that that is not his plan. However, I think that could change.
Well, the time for a motion like that was prior to today. We're confirming for trial today. So I can't really advise you whether I would even hear that motion before trial. Today is trial confirmation, and we are very close to trial at this time. So I don't anticipate a motion like that. My anticipation would be that any motion like that would have been addressed earlier, not today. At this point, we're just getting ready for trial, and any issues that have to be addressed in preparation for trial, the court will try to squeeze in before that. Ms. Collada, you're prepared for trial, correct?
Absolutely, Your Honor, and that's what I was going to comment, that even though I've made this particular record to the court to alert you to that possibility, it will not affect my ability to prepare to pursue the trial, should I retain my current position as representing Mr. Quinn.
Thank you. Ms. Stone?
No additional issues. I'm trying to make sure I have the dates right. Parties' briefings are due, initial briefings due by the 3rd. What was the response date the court gave? Was that the 5th or the 8th?
The 8th. And we'll say noon by the 8th.
Can I stop now, Your Honor?
We're
Does this
almost
cause
done.
number have to do, does this cause number 18-1-0442-34 has it anywhere else?
Is that a question?
Yes.
So please ask any questions of Ms. Collada once we're done with this hearing. We're almost done, and then any questions that you have, you can ask her when we're done. So any other issues that we need to address on that?
So please, but may I have one moment to confer?
Yes.
Thank you, Your Honor.
Thank you.
I have no further issues to address before this time.
Thank you. So I am signing the trial confirmation order at this time. It appears that the defendant refused to sign that. That indicates to me that he was presented with that order and refused to sign it, but I do anticipate that he will be here both for the motion in limine, or the hearing on motions in limine, if there are any, and for trial that will begin on the 15th of April at 8:30. And I've also been presented with an agreed order setting motions in limine and briefing. Of course, the parties are free to agree to any contested issues. And so that hearing can be stricken by the parties if everything is agreed. But I do want to make sure that we address all pretrial contested issues before trial. And when we begin on April 15th, I anticipate that we'll have a jury ready and we'll start with jury selection that morning.
Thank you, Your Honor.
And we are completed for today. Next, I'll call the matter of State versus David Lee, cause number 18-1-443-30.
Your Honor, I'm here to assist the court in that matter. My answer to bar was the
Sir, you are not on the record unless you come
Email
here.
from whatever.
Let the record show that I'm entering the bar with the reservations of Morant remedies.
Mr. Smith, do you represent Mr. Lee?
No, he does not. Your Honor, he does not
Sir?
represent me.
Sir, I'm speaking to Mr. Smith on your behalf, as Mr. Smith has been appointed to represent you, and I believe continues to represent you in this case. I know that you disagree with that.
Is there a contract that says
Sir?
that I represent I, and that I knowingly,
Sir?
willingly, intelligently, and unequivocally?
Sir, please don't interrupt me when I'm speaking. I'm going to talk to Mr. Smith on your behalf, and any questions that you have, you can ask Mr. Smith when we're completed with this hearing. Mr. Smith, do you represent Mr. Lee?
That is my reasoning. I've been appointed by this court, and there's no orders to exchange that.
So it occurs to me that I didn't address the state's motion in the first case that we called.
You're gonna, Ms. Collada and I think that actually one of the responses addresses somewhat of the, from the state's perspective, it's really a motion of limine, and so
So we'll just move it to that hearing.
Yes, Your Honor.
Okay, so I'm sorry that I didn't make that clear.
No, Your Honor, thank you.
So my apologies for the interruption, Mr. Smith. I wanted to make sure that we address everything that we need to on each of these cases today. Mr. Smith, are you confirming for trial?
Yes, I am. I was hoping that we would have a ruling by the court on the motion that you were just speaking about. It is my desire to file a 3-6 motion and have it heard before trial. So the court had indicated in the last case that there would be a hearing on the 9th on motions in limine, and I had intended after hearing that to ask if we could have at that same time a hearing on a 3-6 motion. I believe that I could have that my brief anyway filed by Monday, which would leave the state a little bit more than a week to file their brief, Monday being the 1st of April. And the hearing that I'm proposing would be a week and a day after that.
So
And if I could complete my thought, Your Honor, that motion that Ms. Stone had filed to preclude the argument that the defendants have been putting forward. That motion has sounds a little bit in jurisdiction. As part of it. In fact, Ms. Stone had indicated that in her motion. And just wanted to, I had the benefit of the ruling by the court on that motion. I would feel better about filing my motion.
So let me ask a couple of questions so that I can make sure that we address these issues as fully as we can today. And my apologies as I'm looking down and trying to find the omnibus order that was entered in this particular case. It seems to me that if it were mentioned that there was a 3-6 issue in the omnibus order, the court would have scheduled that earlier.
My recollection that it was reserved. I don't have that order in front of me. If I could look from this Stone resolution.
I'm looking right now to see if I have a hard copy of it.
Your Honor, in order to proceed, I need to know the nature and cause of the accusation. Are these criminal or civil charges?
Sir, if you have any questions, please ask Mr. Smith when this hearing is over.
Okay, Mr.
So
Smith,
I'm-
do you have a contract to show that I knowingly, willingly, and intelligently, and unequivocally agreed for you to be the counsel of the defendant?
So I think the omnibus order was signed in June of 2018.
I believe so, Your Honor. I just gave Mr. Smith my only copy of it. It was June 14th of 2018. That's correct.
Probably unfortunately.
I thought they'd be bringing him up.
I have it.
Oh.
Yes,
Page 3,
yes,
motion to suppress evidence.
yes.
It says, the box is checked, it says no motion to suppress physical or identification evidence may be made. But there's also, it's followed up, that language is followed up by handwritten comment, reserved.
And wouldn't that mean that those kinds of issues would be addressed prior to trial confirmation?
I really just read that very
I certainly would. So that's an issue that I fully anticipate would be addressed prior to trial confirmation. So I'm kind of surprised to have this brought up for the first time at trial confirmation. I understand your interpretation of that word preserved, and so I want to make sure that we address any issues prior to trial. How long do you anticipate that hearing taking?
On my end, I would think it would be longer than half an hour, 20 minutes to half an hour. The heavily dependent upon the brief itself. So my order language would have to be that time. There are no witnesses anticipated.
Then we will schedule it for that Tuesday that's already set aside, so April 9th, with the same briefing schedule. Ms. Stone.
I don't have an objection to that. My only concern inherent in sometimes the 3-6 requires testimony hearing, and I don't know the nature of Mr. Smith's 3-6 issues, so that would be my only concern is whether or not we would have to take testimony from a witness in response to that.
Mr. Smith? I heard you say briefing and argument. I didn't hear you say testimony, but
I'm not asking myself for the testimony. And of course, you still you have to see my motion. But I would think that you need testimony, but I can't speak.
can you give the court an idea of what you anticipate this motion would do?
This motion will argue that the magistrate did not have probable cause to issue search order that affects my property.
That is certainly an issue that I would anticipate would have occurred prior to trial confirmation.
If that's the nature, though, it wouldn't require testimony, obviously, Your Honor.
So, I expect full briefing on that issue before we address it on Tuesday, April 9th. I will address that again, consistent with the briefing of the parties. Ms. Stone has indicated no testimony. Mr. Smith, you're indicating no testimony. So we will take certainly no more than a half hour for that issue.
That's right.
Getting to any other pretrial issues, Mr. Smith, I didn't see that you filed any response to the state's motion that was scheduled for today.
That's correct.
Is that because you expected the court to grant the state's motion?
Frankly, I thought that was a possibility. But I would defer to to the other defense attorneys. My thought was that one of the members would be prepared to argue that, but I'm not at this point opposing that issue.
Are there any other pretrial issues that the court needs to address today?
Not from the state, Your Honor, I can't think of anything.
And Mr. Smith, how many days do you anticipate needing for trial?
I would agree with what was said, really, days.
And have the parties prepared a trial confirmation order?
We have, Your Honor, Mr. Smith has it. I can hand that forward. I just included the language with the briefing schedule on this order, instead of in a separate order, if that works for the court. Otherwise, we can put it in a separate order. The setting of the motion eliminated with the briefing schedule that the court has indicated, we put it at the bottom.
Can you make sure you're standing in front of a microphone?
Oh, I'm sorry, Your Honor. We put it at the bottom of this order instead of putting it in a separate order. Excuse me.
Your Honor, may we have, I have signed this order, and so is Ms. Stone. May we have a few moments so that the opponent can decide whether he wishes to sign?
Certainly. You can discuss with your client off the record. Please make sure that the microphone is turned away, because otherwise it will be on the record.
Let the record show that I'm a third-party intervener appearing especially as paramount interest holder and authorized representative.
Sir, it appears that Mr. Smith wants to have a brief conversation with you. So if you could step away and have a brief conversation with Mr. Smith, we'll address your matter after a little bit. Certainly. So the next matter, do you want me to call a particular matter?
Your Honor, I have just a quick request. I know you're calling them in a particular order, but I represent Trang Lee.
Yes.
Would the court be willing to hear that one now?
I suppose. I don't know. I'm looking at the attorneys. Looks like Mr. Yee might have also had an issue, but Mr. Yee, are you okay yielding to Mr. Simpson?
Your Honor, this isn't a matter that's on the calendar. This is a matter that the court heard yesterday at the change of plea calendar, but there was, the jail came to us and said they need a modification of the JNS.
You have an ex parte?
Yes.
Why don't you hand that to the clerk? And I'll call Mr. Smith's matter, or excuse me, Mr. Simpson's matter.
Action required.
It is brief. Sure. Sure. Very much, Your Honor.
This is the motion.
That's a certain. It is what it is. Thank you. Thank you.
Certainly. My apologies. I'm now calling the matter of State versus Trang Lee, cause number 18-1-545-34. I know that we'll still come back to the Lee matter.
Your Honor, I'm here to assist the court with that matter. May I answer the board with the full reservation of my rights?
Then you're not on the record unless you come forward.
I'm entering the ball with the full reservation of my rights.
Mr. Simpson, you represent the defendant in this case?
Yes, I do, Your Honor.
And is this case confirming for trial?
It is, Your Honor.
Yes, Your Honor.
And have the parties prepared a trial confirmation order?
We have, Your Honor.
You have, Your Honor.
Your Honor, if I can state something on the record.
If you have a question of the court, I'm going to ask that you ask that to Mr. Simpson,
Well,
your
this is not a
attorney.
question. This is a statement.
Okay, at the end of this hearing, I'll let you make a statement.
And Your Honor, I've had an opportunity to track along with what the court has been doing in the other cases here. We do have a proposed jury trial confirmation order that really follows along with what the court has been ordering here. The motion is in the deadline on the April 3rd, the April 8th. That would be the responses due, and the motions in the would be heard on April 9th at 1:30. Some of the other boxes are checked, including the PowerPoint and video. I checked just a foundational box with regard to evidence in general, just standard motions in limine. At this point, though, I would also be looking at the issue, wanting the court to hear a brief 3-6 motion to suppress. And I understand that the court had questions of co-defendant's counsel as to why that wasn't addressed in advance. A couple of things. One thing, at the time that the omnibus order was entered, Ms. Lee was proceeding pro se. I signed off on that order as standby counsel. I didn't involve myself in the substance of it. But I did review that. More importantly, though, just in reviewing the case over these last months, actually looking to see what type of issues could be brought up in a suppression hearing. It really wasn't until recently trying to be a creative in my defense when I came up with a possible issue. I think it's a merit, an issue that has merit and it was eligible. So I'd ask the court to hear it on the same day as well.
I appreciate that explanation. You understand that the court would normally expect that a 3-6 hearing would be heard prior to trial confirmation.
Absolutely, I understand.
So we will address that as well on April 9th with that same briefing schedule. I'll just tell folks that we don't have a half hour for each of these motions. So I am going to limit argument, and most of the court's reliance will be based on the briefs. So I expect everything to be well briefed so that the hearings can be very short, unless the parties anticipate that we'll need a full day for all of these hearings.
I don't, Your Honor.
Very well. Other than that 3-6 issue, and it's with regard to the search warrant as well, or something different?
Yes, with regard to the search warrants, and depending on how, well, it would be the main initial search warrant to go into the actual residences. There was a subsequent search warrant that was based on that search warrant, what they discovered there. I don't anticipate that. Well, I think that the main issue is with regard to that search warrant, because if the defense is successful, subsequent search warrants would be, the argument would be that they would not be available as well.
Do you anticipate any other pretrial issues?
Your Honor, I don't.
So I'd like to address the issue of the state's motion set on for today and Mr. Simpson's response. I appreciate that you filed a response. It appears that both sides have some issues with regard to the evidence in this case. And while I very much appreciate the state's briefing and the issues raised by Mr. Simpson's response, it seems to me that the parties need to talk about what exactly they anticipate in terms of evidence and argument in this trial that may be objectionable, so that the court may address not these issues in the abstract, but very specifically. So to the extent that the parties are aware of specific evidence and specific specific argument in this particular case, that's what I would like to address at the motion to eliminate hearing scheduled for April 9th. I think it's been helpful that both parties in this case have addressed concerns that they have, both sides. And this is, I think, very helpful to the court in understanding what issues might come up at trial. I am reluctant to place any orders in effect in this trial today without specifics. So, for instance, if Mr. Simpson knows specifically a document that the state intends to have admitted at trial that fits the description in his briefing, then we can address that document specifically on April 9th. Similarly, if Ms. Stone finds out from Mr. Simpson a particular argument that she finds contrary to the law that she cited, we can address that very specifically at that hearing on April 9th. Do the parties understand?
Yes, Your Honor.
Yes, Your Honor.
Is that helpful?
It is.
That is helpful.
So I think it's very helpful for the parties to have identified some potential issues, but in motions in limine, I really want to address specifically after the parties have fully conferred about the evidence and argument that they anticipate will be addressed at trial, so that the court can place appropriate limitations, if I think it's appropriate, for things to be not raised in the presence of the jury in this case.
Thank you, Your Honor.
Thank you. Yes.
Do the parties require any further clarification with regard to the motion noted for today?
No, Your Honor.
No, Your Honor.
So with regard to trial confirmation, Mr. Simpson, you said that you heard the other discussion today about other cases. Do you think that it is reasonable that this case take 8 days to trial?
Well, Your Honor, I would say yes at the outset. But my experience as a trial attorney is that things do come up. It's inevitable that things do come up. I wouldn't anticipate that there would be the need for any recess for any type of briefing during trial. So my answer at this time would be yes, 8 days, 8 business days. I would anticipate jury selection be less than a full day. And so should any of my calculations here change, I would certainly try and bring them to the attention of the court at the hearing well in advance of the trial, so that Your Honor and staff can make preparations for 8 days.
Thank you. And have the parties prepared a trial confirmation order to present?
We have, Your Honor.
Yes, Your Honor.
Mr. Simpson, is your client wish to be heard?
Yes.
We did speak briefly before this hearing. I did advise my client that it would be advisable not to talk about the facts of the case. That it's important not to do that. I certainly won't want to prevent her from speaking to this court.
You may.
May I speak now?
Yes.
Thank you.
I'll give you a few minutes. We have a lot of other cases to address, but please.
All right. Let the record show that I am a third-party intervener appearing specially as a paramount security holder and authorized representative agent for Thurston, train line. Let the record show that I am appearing specially as a beneficiary and creditor to the Sequoia Trust Train My Lead. Let the record show that I am women of sound mind and at the age of majority appearing specially under protest, threat, duress, and coercion. I have here the information, the charging instrument. I would like to know if this is the original charging instrument. This one has the prosecutor's wet signature on here. Can someone verify for me that this is the original charging instrument?
If you have any questions, please ask
It's not
us.
a question, I just want to verify it.
So if you have any questions, including what you're calling verification, you should ask Mr. Simpson after this hearing is over, okay? So do you want to say anything else for the record before we complete this hearing?
Rob.
Yes. Also, Your Honor, I am a woman of sound mind and at the age of majority. I am capable of handling my own affair. The court does not have any power of attorney or any authority to make any decision for me. Any power of attorney through implied or express consent between the state of Washington and the person to become a trained mind has been revoked, retract, rescind, and terminate on August 9th. And I have proof for all of that.
So we're ready to address those orders at this time. Mr. Simpson, do you have the orders to present?
I do, Your Honor, and I just wanted to clarify one last thing. We have a briefing scheduled for the 36 motion. It would track along with April 3rd, or does the court want that 36 motion earlier? I didn't catch that.
That briefing schedule is satisfactory to me, if that works for the parties.
I have this, my client indicated that she wanted to sign it, but I don't have a signature on that yet.
Okay.
Would you be able to step back from the podium and have to do that?
Sure, I will sign both of those. I actually want to see that order though, because I want to address any issues I might have with that order on the record before signing it.
And Your Honor, just for the court's purposes, I don't have an issue with the 3-6 scheduling following, presuming that there's a lot of overlap, for lack of a better phrase, between Mr. Simpson and Mr. Smith. Obviously, having at least two, if not multiple, co-defendant counsel indicating that they now have 3-6 motions they want to raise, a week before we're going to be doing a briefing. There's one of me and 5 of them. So if there's going to be a slew now of motions in the last week, that may create an issue for the state in terms of timely and appropriately responding. If there's a lot of overlap with the same issue, then it's not. But if all of a sudden we're changing all of the motions, then it becomes an issue in a short period. So that would be the state's only concern I would raise. I haven't heard that yet, but I also haven't seen the briefing yet. So I just wanted to make that record clear to you.
I'm not sure what to do about that.
If there's anything yet until we see the briefings.
I'm certainly hoping that the parties will talk so that it's a reasonable amount of briefing, also a reasonable amount of briefing for the court, frankly, to review. I will tell you that I am out the entire week before that hearing on the 9th. So while you are limited in time, I am even more limited in time. And so I cannot get through a large amount of briefing in a way that I expect myself to, which is to look up every single case and statute and rule cited in any of the briefing if it's lengthy. That just can't happen. And again, I would expect that if the parties anticipated that, it would have been done prior to trial confirmation. So I don't expect that any of these issues would be any basis to continue the trial or to continue that hearing on April 9th.
Thank you.
So, trial confirmation order. So again, Mr. Simpson, I see that there's a box check that says video. Is that something that you've reviewed?
Yes, Your Honor.
And so,
I'm going to be reviewing it again. But
Okay.
What I anticipate is what was mentioned earlier in the prior hearing, that the state would be winnowing down any proposed video evidence and be providing counsel with advance notice of what exactly they would be proposing to bring and be able to review that. It sounds like it's about 15 minutes worth of video, and so I don't see an issue with regard to that.
and so, although the box is checked saying standard motions in limine, I would like to address even standard motions in limine on the 9th, so that again, we're ready to go with the jury on the 15th of April. Is that what the parties anticipate?
Yes, sure.
Yes, Your Honor.
Okay. And then, I don't know who checked PowerPoint, but,
I did, Your Honor, just for the same reasons I've stated previously on the other matters. There
Okay.
wouldn't be any difference in this case.
and do you anticipate any issues with that, Mr. Simpson?
No, Your Honor.
Very well. So I will sign that trial confirmation order after it's been signed by the parties and the attorneys. The clerk indicates to me that typically they do not schedule matters off of the trial confirmation order. I think that that is corrected by adding the clerk's action required on the order. Is that correct? Okay, well, I will direct the clerk to set those matters on the trial confirmation order that indicates those need to be scheduled. Anything else that we need to address on the record today?
Yes, Your Honor. I would like to see if this is the original judgment, so I can settle and set up all these matters so that we don't have to go through public resource by going to trial or going to anything else.
Please ask your questions of Mr. Simpson.
But it's not a question, I just want you to certify this is the original copy.
So it sounds like you have a request of the court that needs to be done through Mr. Simpson. So please talk to Mr. Simpson after this hearing today. And we are completed. I will sign that order after it's been signed. And I think we've addressed all of the issues for this hearing.
We have, Your Honor, thank you.
We are completed.
We have two defendants left, Mr. Ken Liu and Mr. Matthew Tran.
And I have been handed up the order, the trial confirmation order in the case of David Lee, cause number 18-1-443-34. I am signing that order at this time. It appears that Mr. Lee wrote something here where it is that he's supposed to sign. I just want the record to show that the defendant was present and is aware that this case has been put for trial. Thank you. And so, Ms. Stone, do you have a request with regard to the order of the remaining cases?
I would ask for Mr. Liu to go next, just because Mr. Swaby gave me his trial confirmation order first.
State versus Ken Liu, cause number 18-1-444-34.
Good morning, Your Honor. Christopher Swaby on behalf of Mr. Liu. Mr. Liu has maintained throughout this prosecution that the court doesn't have jurisdiction over him, the individual. That this case is really about Ken Liu, the economic corporation entity. I think that that's what all of the other individuals have been trying to assert this morning. I know the court understands that that is the issue. I'm prepared to announce ready for trial. I've tendered to the court a trial confirmation order. I want to apologize to the court and counsel. I was sick most of last week and into this week, so I did not have an opportunity to respond to the state's motion. I'd ask if I could file a response to that motion in connection with the other motions in limine that are due April 3rd.
Well, let me say this. Your client is present in the courtroom. Ms. Stone is here for the state.
Yes, Your Honor.
I do want to, I very much appreciate your apology. I expected a response to the motion and didn't see one. I think that, as I indicated in a previous case, I think it might be more helpful, rather than filing a response now to the state's motion, for the parties to confer regarding the exact evidence and argument they anticipate for each of their cases at trial, so that we're really briefing and the court is hearing contested issues with regard to evidence and argument that counsel actually anticipate will be raised at trial.
Well, then I can do that without conferring, no disrespect to counsel. I don't believe this is a defense issue. The defense that I would put forward is something along the lines of general denial. The state is alleging a certain set of facts. I don't believe that Mr. Liu is engaged in criminal behavior in this set of facts. So I think I'd be arguing actual innocence. I think the motion that Mr. Liu wants continue to respond to, and I think it addresses the state's motion, is really a motion to dismiss. Mr. Liu is saying the activity at issue in this case is economic activity, not criminal activity. And as such, he is not here as an individual, he's here as a corporation. And he has rights as a corporation under the UCC, the Uniform Commercial Code. I'm going to suggest that he means more than the Uniform Commercial Code, he means also those codes appropriate under Washington law. And he'd like to be able to argue those as a reason why he can't be prosecuted at all. I will not be arguing at trial to a jury or to the bench that Mr. Ken Liu is not a separate individual, someone who is alleged to be seen in videos or alleged to have been at the scene of events that the state says are criminal. Mr. Liu all along has said this is a business matter that ought to be handled in a civil context. And I think there is some argument that all of them could be making towards that end, Your Honor. So my proposal would be to file on April 3rd a motion to dismiss under those basic arguments. As I think I shared with the court recently, I've been practicing almost 29 years. I'm not going to make illegal or unethical arguments at trial. I'm not going to in any way seek to confuse the jury to the state's detriment or in some way that is appropriate or is illegal.
Your Honor, can I mention about the probation of my rights?
Sir, you're interrupting these proceedings.
Your Honor, this is a case having nothing to do with I. The jokes are not been up there.
Mr.
You don't make me
Sweeney,
here.
So I have a response to what you just said, and I want to address that. It sounds like you want to make a motion to dismiss the charges in this case, and I would have anticipated such a motion would have been filed way before the trial confirmation hearing.
And I think you're right, Your Honor, it should have been. In playing through, I don't have a good explanation for that, Your Honor. Balancing all of my other cases, I expected this week to be in a murder trial, but for an illness for one of the state's complainants, murder and assault one, attempted murder. I would have been there. I have been really focused on that. I am now turning all of my attention to this case, and in doing the preparation and reviewing and being prepared, getting prepared for trial, I realized I should have filed that before. And I think, Your Honor, that this, Mr. Liu, the person against whom the information is lodged, needs to have that motion filed in order to preserve whatever appellate rights he has on that. So I'd understand if the court wanted to sanction me, but I'd still ask the court's permission to file that motion.
Well, it's just that you put the court and the state in a pretty awkward position as we're talking about trial issues and trial readiness here. You're confirming for trial,
Yes.
but now telling the court for the first time, without having filed a motion, that you want some sort of slot to file a motion to dismiss.
Your Honor, I anticipate the court's response to the motion, so I don't, which is not in any way suggesting the court is unfair or won't give me my hearing, but I believe that we will still be moving forward to trial. And this is, in my mind, a way to protect his record, and to the extent that we were to lose at trial, to give him yet another argument to be made on appeal. So I don't think it will hamper the state, and it's not as if I haven't suggested this to counsel the state in more informal conversations, typically during our plea negotiations, and way to resolve the case. I know it is an issue of first impression for the court because I'm only raising it now, but counsel for the state knows that this has been something that I have argued in terms of helping the state understand Mr. Liu's position going forward. I'm still hoping this case resolves short of trial.
Well, I appreciate that, and I'm hopeful that those negotiations continue.
Yes.
But what I'm telling you is that although counsel may be familiar with these arguments, I am not,
Yes,
having
Your
never seen any briefing
No,
on the
you're not.
topic that you're talking about. And I will have less than 1 day to prepare. And I don't think that's fair to me or your client.
No, it's not fair to you, Ryan. Because I want the court's full consideration, even if the court ultimately denies the motion.
And you will get that. I'm just concerned that, that we won't be able to do it on the 9th. I think what I'd like to do is to set that hearing perhaps a day later on the 10th.
Thank you, Your Honor.
There's no objection to that, Your Honor. And for the court's purposes, this, Mr. Swayze is correct. He has indicated this to me, and that's quite plainly part of why this briefing from the state came up. Without having that motion, that conversation has raised obviously significant concerns for the state about the relevant evidence and law that would be argued to the jury, and it's in large part based on those conversations. And so I've not seen the briefing, but I'm familiar with what Mr. Swayze has indicated, and that is in part of the proactive briefing. I would describe it from the state to try and preemptively address that. But I have no objection to doing it on the 10th, and can make myself available for whenever the court is available and Mr. Swayze is available.
So 1:30 on the 10th?
Thank you, Your Honor. Oh, I did. I'm sorry. I gave the order up.
Sorry, that's this one.
Thank you.
And I have signed the trial confirmation order in the case of State versus Trang Lee, cause number 18-1-545-34. With regard to a motion to dismiss that would be heard on April 10th at 1:30, what do the parties anticipate with regard to briefing?
I would just ask for a day bump each way, Your Honor. So Mr. Swayze can get his briefing to me by the 4th, and then I could return my briefing by the 9th at noon.
Is that agreeable, Mr. Swayze?
Oh, yes, of course, Your Honor.
Very well, then that will be the order of the court. I see that those briefing deadlines are not in this written order, but they're on the record, and I know counsel will abide by them.
Absolutely, Your Honor.
In looking at the order, we also have some boxes checked with regard to motions in limine and video. Mr. Swayze, do you need a moment with your client?
My client asked me to make a representation, and I will do so after the court finishes addressing that.
So I just wanted to know whether you've reviewed that video evidence and you have any specific objections that we can address either today or on April 9th.
I have reviewed the evidence. I don't know if I've listened to some of the representations other counsel have made, Your Honor. It's really quite a bit of video. So to the extent that the state is offering some up, and I've heard the state say it would try to cut down the amount, I don't know what objection I would have until I saw what it was they were offering. I want to say there are hours.
Right, but since Ms. Stone has indicated it will be less than 15 minutes of video that she anticipates using in trial, do you anticipate being able to bring any issues up in your briefing that
Yes.
you would file on April 3rd?
Yes, Your Honor.
And are there any other issues that the court needs to address today?
Your Honor, I have one. I am out of town on April, well, I'm supposed to be out of town on April 25th for a conference. I assume we'll be sitting on the 25th. So I don't know if the court had planned to sit on Fridays. I cannot be here on the 26th. I cannot be here on the 26th.
So your trial conflicts include the 25th and 26th of April?
The afternoon of the 25th and on the 26th, yes.
So I would expect you to put that in the scheduling conflicts? It's good that you're bringing it up.
I thought of it.
And Ms. Doe, there are no conflicts a part of the state or state's council?
None, no, Your Honor. I'm here the whole time. Ms. So indicated she's here the whole time. She's, as I indicated previously, she's out right now, but is returning, I believe, the beginning of this week.
I mean, I think the court's going to ask me about that. I do think that we need, yes. Your Honor, I also put 12 days for trial. Given the amount of evidence against each separate defendant and defendants in total, given the fact that there will be 6 lawyers going forward, I'm told Ms. Stone is really concise in her questioning. I have some experience with Ms. Zoe, 3 months of it, to know her style. I still think this is a 3-week trial. I'd be happy to be wrong, but I'd note to everybody, I said it was going to be at least 12 weeks that we were in the other trial, and that's what we were. I think that this goes into the week of April 29th. Frankly, I think it probably goes all the way to the 2nd. And I think, I'm not a judge, I'm not going to be a judge, but I think maybe we should let the jury know that this could go that long. Maybe everybody else is more concise than I am and briefer than I am. But I think each defense attorney trying to protect his or her client, I don't see how it can be done in 8 days.
So let me say this, I appreciate that. As counsel know, I've been in very lengthy trials before, one of which I think was with Ms. Stone. I am hopeful that this is not one of those that goes that long. I am confirming it for 8 days. I appreciate that you put down 12 days. I'm going to cross that out and put 8.
Okay.
But I'll tell you this. The court anticipates that the attorneys will work hard to be as concise as possible and that 8 days will be necessary for this trial. That is not what I will tell the jury. My practice is to always tell the jury a much longer period of time than I anticipate for trial. I do that for a couple of reasons. I would rather have them be happy that it's shorter than disappointed that it's longer, or worse yet, have conflicts that weren't addressed. So I will certainly, and we'll address this pre-trial, I will certainly give them a much longer time frame than I anticipate the trial taking, because we want to know about conflicts, just like you've indicated yours. We want to know that much longer than we anticipate. I appreciate that we're hopeful about 8 days, but I want the parties to know that I will do everything in my power to make it as concise as possible with the jury's time. That means if we have issues that come up, we might need to address them at 8:30 or at 1 o'clock or things like that in order to be ready to go with the jury. I want to be very mindful of the jury's time throughout this trial. So I appreciate what you've said, and I don't necessarily disagree with what you've said. Things come up. I'm not going to put a timer on questioning or argument yet, at least. But I am very hopeful that we can try to be more efficient.
Thank you, Your Honor. I also checked special questionnaire. I think drug cases, it's been my experience that they bring up sort of special issues with jurors. Even today, in 2019, people have very strong feelings about drugs. Drugs other than alcohol. And all of the defendants, I believe all the defendants, are of Asian descent, and race to me is always an issue. And I think I would like to take a crack at devising a short, one-page, maybe 4 or 5 questionnaire that goes out to the jury to address those issues. I can say that during the murder trial this summer, we did something similar, and we weeded out a lot of people who had some really strong feelings about race that we would not have gotten to, I believe, just in an ordinary exchange of questions. And to me, that's incredibly important.
So let me say this. When I was a civil litigator, we used juror questionnaires, special juror questionnaires in almost every case. That seems to have gone out of favor. And we use them very rarely in Thurston County Superior Court. And typically only in certain types of cases that aren't the types of cases that you described apply in this case. That being said, I will address the issue of a special questionnaire after 2 things occur. The first thing is we need to see the proposal. But the second and perhaps more important thing is that I would expect all counsel to confer regarding that special questionnaire. And I would hope that any questionnaire that would be submitted to this court for approval would have very little, if any, disagreement. And I will address disagreements, or perhaps counsel will convince you it's not necessary, I don't know. What we do not have time for in this case is for me to hear something for the first time and all the other counsel are hearing it for the first time, and so it's a discussion on the record.
Absolutely.
That's what I cannot have.
Understood.
Counsel, you'll hear this from me many times throughout the trial. Anytime an issue comes up, my first question is going to be, have you discussed it with all of the other attorneys? Because we just do not have time for essentially a discussion on the record where someone says, well, Ms. Stone wants to do this, and I'm just looking at it, and you're talking on the record while you're reading it for the first time. That's not something we have time to do on the record. So everything that will come up before the court needs to be addressed among the parties first. Understood, Your Honor?
Understood.
And then I'm happy to address any contested issues.
Thank you.
Thank you, Your Honor.
So we need a date for a proposed questionnaire, and in my mind, I'm thinking that proposed questionnaire has to be addressed by the parties, at least, prior to April 8th or so. And I anticipate addressing that perhaps at the April 10th hearing.
Yes, Your Honor.
And I will just say that one of the problems with that is that only your case so far has a hearing on April 10th. So
I don't think we need a special questionnaire, and I haven't heard that from any of the other counsel yet. This is, I think, Mr. Swaby's concern. I don't know that I'm opposed to it, but I don't think it's necessary either. So I think it's something we could probably address on the 9th with everyone if it's an agreed.
I will get it to everybody by the 2nd, and then we can discuss it, and I'll hear what they have to say. If everybody else feels it's unnecessary, Your Honor, I don't have any problem withdrawing it. I have a sense, I've asked around, the court will let me address these issues during my time in jury selection. Maybe that'll be all that I get.
Very well.
But I'm putting everybody on record. I think race is an issue, and I'm going to address race one way or another.
Understood. So I'm not going to set a hearing for the special questionnaire, except to say that the court will need to address that prior to the first day of trial. So if the parties anticipate needing the court to address an issue on the special questionnaire, it needs to be noted up. And of course, you'll need court approval to do that.
Very well, Your Honor.
Yes, Your Honor. Thank you.
There was one, I don't know if the court is finished with our trial confirmation list, but Mr. Liu wanted to make sure that I made it clear if we're going to trial, he wants a bench trial.
Well, we've gone through this confirmation order line by line, and it says jury trial confirmation order, so I'm confused.
When he came up and you asked me if I needed time, that's what Mr. Liu had just said. I'd like a bench trial. That is the first I'm hearing of it. I prepared the trial confirmation order, and truth be told, Your Honor, I hadn't paid attention that it's a jury trial. Is there a separate bench trial confirmation order?
Yes, there is a separate order.
I've never seen it because I have never once in my career asked for a bench trial. So this is something new to me. Is it possible to scratch out the word jury and put bench on top of that?
No. Because it's different in content. So I'm just trying to think practically through this, because all of these matters are combined for trial. How do you anticipate going forward with your client having a bench trial and the rest of the defendants having a jury trial?
Well, having never had this experience before, my first thought is that at the end of the case, when I am making closing argument, I'd be making it to you and asking you to make the ultimate decision on guilt or innocence. And the jury, I don't believe, needs to be told that until they get to jury instructions, when they get packets of instructions for the other five defendants, and not Mr. Liu. And the court would review those jury instructions in coming to its conclusion on the case.
I know that sounds like it might work. I anticipated many issues coming before the court this morning. That was not one of them. And as I tell juries at the end of just about every case, their job is very different from my job in a trial. So my mind is centered around issues very different than what the jury is considering while hearing evidence. That being said, I can't really address that right now. What I'm going to ask is, if that is truly your request on behalf of your client, and you believe that your client has gone through the process of waiver, which you know has some meaning to this court, that be addressed at a later time and not today. Today, I'm signing this jury trial confirmation order, which the attorneys have worked through line by line.
And it may be mooted, because as I understand under Washington law, the state has a right to present before a jury, and if they want a jury trial, it matters, I don't want to say it matters not, but it could lead a court to give the defendant a jury trial in any event.
Even in the case of an agreed motion, the court has discretion to deny that motion.
So, as the court understands, I hope the court has at least that much faith in my abilities. that I fill out this form and I prepare for a jury, and I'm arguing about jury questionnaires because that was my thought going forward. My client, though, came to me, and the only thing he's asked me today is to address the request for a bench trial. So I will confirm with him, I will make sure he understands, and I will address this again with the court and counsel at a later date.
And let me just tell you, I am only going to address that request if I have a written waiver signed by your client
Of course.
in writing prior to that.
Of course, Your Honor.
So, with that, do we have anything else that we need to address on the record today?
Nothing to state, Your Honor.
Mr. Swady, I thought your client indicated that he wished to be heard on the record before we end.
He may have. May I have the court's indulgence for a moment?
You may.
Your Honor, may I take the bar to full race and bar my rights and remedy?
Go on, you don't have to ask permission, go on.
Let the record show that I enter the bar to full reservation of my rights and remedies. Your Honor, let the record show that I am here, the third party intervener, appearing especially as paramount security interest holder and authorized representative agent for Thurston Liu, Ken. And that I am appearing especially as a beneficiary and a creditor to Security Trust Ken Liu. Let the record show that I am a man of sound mind and at age of majority, appearing especially under protest, but duress and coercion.
So, Mr. Swady, I haven't signed.
Your Honor, does anyone here today have the original instruction document?
If you have any questions at all, please ask Mr. Swady when this hearing is over, and that would be one of those questions you can ask your attorney.
Your Honor, in order to proceed, I need to know the nature and the cost of this accusation.
Please ask any questions of Mr. Swady when this hearing is over.
Your Honor,
And I provided that trial confirmation order back to Mr. Swady so that it can be signed by the defendant, and then I will sign it. And whether or not the defendant signs that order, I am confirming for trial, and so the defendant is on notice that this matter is confirming for trial and is required to be there.
So, this person has issues concerning, do you want me to make the remark? The validity of the state of Washington, an artificial person prosecuting this case. He's got concerns about the notion of criminal versus civil charges and the jurisdiction to hear a criminal charge. I believe you've heard this before, but I want to make sure I'm making his record, Your Honor. My client is of a mind that this is a court sitting in Admiralty and not in common law or criminal jurisdiction. And that this notion of the state of Washington being a prosecutor, I suppose in the form of Ms. Stone, as opposed to an individual suing my client, means this is a legal fiction. I think I've made live for the court what it is as the basis of what is written here. It's formal language, and I'm not, these are questions I think a lay person would have. I think I have put them into terms the court could accept. In essence, my client is saying he doesn't have a contract with me, and it's true, he's never signed a contract with me to represent him. He has not signed a contract conceding jurisdiction of this court or the state against him, and so he objects. And I think I made this clear at the start, but I want to make sure I have again, that he objects to this court, the jurisdiction of this court over him, the individual. If there is a suit that the state of Washington wants to enter alleging some business malfeasance, that is something separate and apart from this. And
Mr. Swady, I'm sorry to interrupt, but we need to really
yes, I'm sure we do.
Continue with this hearing. I did allow you and your client to make a record of things that the court is not going to address today. I'd like to get that order signed so we can move on to the next case. So whether it's signed by your client or not, I will sign it. And so you may confer with your client regarding that signature. And I'm going to call the next matter.
Yes, as long as we have to leave it.
And so the next matter is State of Washington versus Matthew Tran, cause number 18-1-447-3.
I'm here to assist the court with that matter.
Okay, you stepping up? Yeah, I'm stepping up.
Let the record show I'm entering the court with my full reservation of my rights and remedy.
Ms. Segal, do you represent Mr. Tran for the purpose of this case?
I never entered a contract with her.
Sir, I'm not asking you any questions. I'm going to be talking to Ms. Segal on your behalf. If you have any questions, please ask Ms. Segal, and do not interrupt these proceedings.
I'm sorry, I'm not trying to interrupt. I wait till you finish speaking. But I do have a question. Does this case have anything to do with I?
All of the questions that you have need to be asked of Ms. Segal after this hearing is over. Do you need to talk to Ms. Segal before we begin?
Yes.
Okay, you can have a minute with Ms. Segal before we begin.
I'm not going to do that. I'm not going to address that. Tell me what that is, because it's not compliant. It doesn't comply with this.
I want to ask you a question. The charging issue, I haven't had a arrest warrant, there's a search warrant, and they're bringing me this car.
Things like the chip.
I've asked you anything else?
But I have everything on the computer to show you. I just need you to, as far as the pronouns and all of this stuff, I cannot effectively represent you. I'm your employee. I really don't.
Ms. Segal, you represent the defendant in this case.
Well, first I put out some questions at this point, and as Your Honor knows, Mr. Tran previously filed a motion to go pro se, and I, at the same time, filed a motion to withdraw. And part of what the motion to withdraw was based on was not only Mr. Tran's desire to go pro se, but my inability, excuse me, to effectively represent him when, upon meetings with him, we discussed certain matters, and I thought I had an understanding of what he wanted, and he had an understanding of what I intended to do for him as his attorney. And then as we stepped in the courtroom, or filings were made without my knowledge, Mr. Pan was effectively attempting to represent himself, and I felt that I did not have any effective communication with him. I think we're at this point again. I've had communication with Mr. Tran when we meet, when we talk, when we email, when I talk to you on the phone, when I talked to him this morning before court started. I had an understanding that we were going to step up and confirm for trial. I'm prepared to do that as his attorney. However, Mr. Tran is once again now telling me he doesn't understand that, he doesn't know what's going on, he doesn't want me to represent him. And I honestly feel that we have an absolute breakdown in communication.
Ms. Segal, I'm not going to hear that motion today. I haven't received a motion from you, and it sounds like the situation is no different than before. So you remain as Mr. Tran's attorney, so we're going to proceed with you representing Mr. Tran. The court will only address a motion like that that's properly noted and brief.
And Judge, as I indicated, I do not feel that this was something that was needed to be filed until we stepped into court once again here today. I will meet with Mr. Tran after court. We will once again attempt to find some common ground. As for if we are proceeding, and I am proceeding as Mr. Tran's attorney, I'm prepared to confirm for trial. I have a couple of the same issues that the courts heard earlier. In speaking with Mr. Smith, one of the concerns I do have is the potential 3-6 motion and some documents that were filed with the clerk's office that Mr. Smith was able to obtain that I was not even aware of, and I think they perhaps were not tendered in discovery to me. There were probable cause findings by Judge Price and by Judge Dixon regarding GPS monitoring equipment and an ability to place that on vehicles, and that is something I just don't have. I wasn't even aware that that existed until I spoke with Mr. Smith a couple of days ago in court. I'm sure Ms. Stone and I can confirm, I can get that. I don't think that's going to hold up going forward, but there is some outstanding discovery as far as I'm concerned that I've just recently been made aware of.
Okay, just a moment.
Okay.
Ms. Stone, do you know what that's about?
No, Your Honor, our records show that all discovery has been provided to all counsel. I actually looked at it last night. There were thumb drives that were provided and documents. It's voluminous, but it's the same copy that's been made for each counsel. So if all the other counsel have it, then Ms. Segal also has it. So I don't know if maybe she just overlooked it or if it's somehow if it's in a document that she's associating with something else. I don't know the explanation for that, but from the state's perspective, Ms. Segal has it.
So I'm going to ask the attorneys to confer
Well,
following this hearing, just to make sure. I of course haven't seen the discovery myself, but I understand that it is quite voluminous. It is possible with multiple cases that something got missed, or there's some sort of miscommunication. I don't know, but if the parties could just talk about that and make sure that any discovery issues are resolved as quickly as possible.
We'll do that, and I'm not indicating that this was any malfeasance on Ms. Stone's part. It's something that, and I did look through my discovery. I did not see these probable cause findings, and I was made aware as I spoke to Mr. Smith regarding this. So there is a potential that I would have a 3-6 motion. What date did the court want that filed and briefed by if there was a 3-6 motion that was going to be filed?
Well, and I don't know what this is about, so help me understand this.
Just as far, just
A search warrant issue?
potentially a search warrant issue. Again, I have to have all the documents to be able to go forward on that.
Well, the reason I'm asking is because, as you probably heard me say earlier, I would anticipate that any issue like that would have been addressed and set for hearing prior to trial confirmation. It is not my expectation that at trial confirmation, we're talking about squeezing in a very important evidentiary hearing prior to the trial that's only a couple of weeks away at this point.
Judge, all I can say is there was new information that I was made aware of, and perhaps I missed it, perhaps it was just something in discovery that got lost, but I was made aware of certain things this week. That is why I feel that there's a potential motion there. And again, I've got to look at all these things myself to be able to be aware of. So all I can tell the court is it is a very important motion if it needs to be filed, and I will file it by the 4-3 date. I also have an issue as far as potential questionnaire. I believe Mr. Swaby, even though Mr. Swaby goes forward as a bench trial, as a jury trial, I think the two issues he addressed, that the drugs have a very strong, people have a very strong reaction to any form of drug case. That's been my 23 years of experience, and I'd like to.
I'm sorry, may I be excused? I am not a matter in the jail.
Yes,
I apologize.
I'm signing the trial confirmation at this time in the case of State versus Ken Liu, cause number 18-1-444-34. I've signed that, and that matter is completed.
Thank you, Your Honor.
Ms. Segal, I apologize for
No
the
problem.
interruption. I also want to say that I very much appreciate your patience this morning. You are a busy person, like we all are, and you've been here all morning. It's 10:15 now. We started at 8:30, and these hearings are taking longer than I anticipated, but it's really important to go through line by line, and I apologize that it's taken so much of your time.
Absolutely, Your Honor, and I hope we have condensed down some of the issues. I'm trying to listen carefully. So as I was saying, the drug issue and the race issue, I think, are things that should be addressed in a special questionnaire. All the attorneys have been emailing with each other. We have been conferring. I don't think it's going to be a problem for us to present anything together. I've heard Your Honor's previous comments of Mr. Swaby's case, and I will adhere to all of your concerns there, make sure that we get a concise and reviewed document that can be presented to the court. My only other issue is I am moving my over 80 mother out from Illinois to Washington State, and that right now is scheduled roughly between May 1st and May 9th, that I will have to be in Illinois, will not be here. I believe Ms. Stone indicated 12 days on here. Mr. Tran is not in a great deal of the documentation and the testimony, but as I understand this, that this will flow as it flows, and everybody's information will have to come out as it comes out. But as far as lengthy cross-examination on my part, I don't anticipate that, and I think I anticipate there's a number of witnesses that will not necessarily apply to Mr. Tran. But I do have concerns if we end up going into that the week of the 29th, that I potentially will not be available for approximately 7 or 8 days.
And did you put that
I
on?
did put it on the confirmation, Judge. And I marked a special questionnaire with a little delta above for defendants. State had indicated they were not looking for that. Everything else is basically standard. We are looking for a general denial. The same issue with the video that the court has previously addressed. I believe I will have time. Ms. Stone gets us something that's in the 15-minute range to review as to what we have. I have all of the video documentation. I can say that my client has concerns about the original arrest warrant, original charging document, and he is now asking about a bench trial. I think these are all matters that can be addressed outside of the court, and I can show him whatever documents. And like Mr. Swaby, I came from Chicago. I've done a lot of bench trials. I'm very familiar with that as a procedure. I'm aware that there would need to be a waiver. I will discuss all that with Mr. Tran, but I would confirm for jury trial, because I think right up to the moment that we start, Mr. Tran can change his mind and want a jury trial, and we need to address all the jury issues.
And you also understand that the court would need to have a written waiver
Yes.
of jury before I considered that request, and then the court could also deny that request.
I'm unfamiliar with that as a procedure, but I believe that's Washington versus Illinois, but I will address that with Mr. Tran.
I appreciate that. Ms. Stone, what date did we discuss that any special juror questionnaire would need to be filed?
We didn't specifically say what date the special questionnaire would need to be filed. I believe Mr. Swaby said,
I think he said the 3rd.
I thought he said the 2nd.
Oh, maybe the 2nd, yes.
But either way, I'm fine with that either way. I think his intent was to send it out to counsel first and see if it was something he even wanted to do, but I think it was either the 2nd or the 3rd. I know what we talked about in terms of his motion to dismiss specifically with the briefing schedule is bumping everything essentially 24 hours from the other briefing schedule, because his hearing is on the 10th for that matter. So I don't specifically recall which date he said for the special questionnaire.
Well, unfortunately, it looks like we didn't write down that date, and that's unfortunate because the language that's written in the order, the standard language is proposed questionnaire is due by noon Thursday, the week prior to trial. Obviously, that was not what we discussed on the record. So we'll just put in this order that any proposed questionnaire needs to be filed with the court by April 3rd. Noon, April 3rd. just a moment, I'll give you an opportunity to speak. I just want to make sure we've addressed all of the issues on the order.
And I think that matter, that one says 12 days, I don't know if I wrote that or Mrs. Seeger wrote that quite plainly.
I think you wrote that, but I think that's what we,
It may have been at the beginning before we started discussing it. So the state's position is still 8 days. Obviously, Mr. Swaby has made his record, so we can change that to 8 days.
and obviously I have the same concerns Mr. Swaby has, and the court, again, has already addressed that, of better to let the jury know longer period of time. Ms. Stone and I tried a case together recently. We can move things along very well, I believe, and the court is aware that I've tried cases for Your Honor, and take your word that I always endeavor to focus on the real matters and not make additional arguments.
I remain hopeful that we can have this matter completed, excuse me, in 8 days of trial. But as I indicated previously, that's not what I'm going to tell the jury, because I really want to make sure that we are able to complete this. I have a concern that I just want to put on the record about the dates for trial. It is not my practice. I don't believe I've ever taken a week off in the middle of a long jury trial. I think it's understandable that we need to take days off from time to time, and I have done that. Mr. Swaby has already indicated a conflict with at least a half day that we would have scheduled for trial, and that he would be unavailable on a Friday, which normally would not be a trial day. But we're going to be talking about these potential conflicts as we go forward throughout the trial. I'm concerned about unavailability from May 1st to May 9th. Again, I guess that's my comment to the parties, that once we start the trial, we are going to finish the trial, and I don't anticipate taking a week off with the jury. So I just want to say that.
Well, and for that, to that end, Your Honor, the state is out of state the 9th through the 14th of May. So the state has to complete this trial in the time schedule that we have allotted.
Well, and hearing that, Your Honor, I don't have any choice about moving my elderly mother, and she's selling home, and there's a lot of things that were coordinated, and that actually happened more suddenly than I thought was going to occur. So bearing that in mind, I don't know that I can confirm if the court is saying, if we're in trial and the trial is still going on May 1st, Ms. Seeger, you have to be in court here. I can't do that.
I understand, but what I anticipate in a lengthy trial is that we're going to know this going along. So if we need to begin early, if we need to have half-hour lunches, whatever we need to do to fit it in that time frame is what I'm proposing.
And I'm certainly willing to do that, but I'm making the court aware that I gotta get on the plane.
I see that here, and I understand that, and I don't know the nature of Mr. Swaby's unavailability either. But I expect that in a trial of this nature, we're going to be talking about pace as we go along, and we'll be making whatever adjustments we need to in order to fit everyone's schedule.
And I'll certainly do my best.
Okay. So, is there anything else we need to address on the record?
Not from the state, Your Honor.
Not from trial matters. Mr. Tran would like to address the court.
Certainly, and I've signed that jury trial confirmation order. It appears that Mr. Tran has refused to sign that. I will just say that that he's present and he's heard through these proceedings, and it is confirming for trial. That's a required appearance, and I'll hear from you.
Your Honor, I just want to stay on the record. I'm a living man of flesh and blood, sound, common, and handle my own affairs. I do not object to having Carolyn Segal standing by and assisting with the matter, but she does not represent or make the decisions for me. So I want to state that on the record. And I also want to request that Heather Stone provides the arrest warrant, the original arrest warrant, search warrant, as well as the charging document. And also, I noticed on the copy of the, I believe it's the charging instrument, they're going by presumptions because all the documents say that the defendant, Matthew Douglas Tran, appears and appears and appears, and that is more of assuming and presumptions. That's not facts. So I want to stay on the record, does this court operate in assumptions and presumptions, or do they work with facts and truth?
Any questions that you have, I'm going to ask you to ask those of Ms. Segal after this hearing is over. So feel free to have that discussion with Ms. Segal. Anything else for today?
I don't think so.
So this is another case that the state has made a motion that is noted for today. I didn't see a response to that motion, Ms. Segal. Is that because you are in agreement with the state's motion?
Judge, my only response to the motion is that we would not be making any illegal arguments. I do not intend to pursue anything related to the UCC. I would make that clear to Mr. Tran, so I don't believe any of the concerns or issues addressed in that motion are something that is applicable to my case as far as I am concerned, or to Mr. Tran.
Very well. Then I don't think that motion is really something that the court needs to address today. I'm not going to address it. It looks like the parties are basically in agreement. But with regard to any specifics, I'm going to ask the parties, as I did in prior cases, to have a conversation about very particular arguments and evidence that the parties anticipate using at trial, so that that briefing schedule that the court has established for motions in limine can be addressed as to any of these issues. We want to be completely ready to go on the first day of trial.
And Ms. Stone has certainly made efforts to have ongoing conversations with me, and I believe all other counsel involved in this, and will continue to do so.
Excellent. We are completed then.
Thank you, Your Honor.
And I believe I've addressed all of the matters special set for this morning.